Dear students, good afternoon. Today we're going to discuss the topic of human rights. So we are going to work with the following learning objectives. We will outline the development of ideas about human rights, including differences between civil, political, and economic social rights, and we're going to explain the main institutions, declarations, and treaties on human rights. So you can find most of the information, as usually, in Globalization of World Politics by John Bayliss and chapter 31, and you can also find information in Joshua Goldstein International Organizations, Law and Human Rights, chapter 7. So let's move on now. If we are going to speak about human rights, 75 years ago, actually, human rights were not considered to be legitimate from the perspective of from an international perspective, and they were normally mostly related or mostly addressed on national level, and the ways the state actually treated its own nationals on their own territory did not really matter on international level. It was just a matter of sovereign rights. So even though today slavery, for example, or the conditions of labor are considered something illegal, at that point they were not part of the human rights set. Okay. Now, we discussed before about League of Nations, and one of the failures of League of Nations is that it was not really able to address the human rights as one of their goals. The situation actually changed dramatically after World War II, and the question of human rights was addressed in a very serious matter after the atrocities committed during the Holocaust, and as well by the growth of the civil society in most of the states of the world. And of course, because United Nations adopted the Universal Declaration of Human Rights in 1948, this actually provided the core or the foundation of norms of the human rights. Now, of course, we discussed about the human rights as part of the international legal system. And we also discussed that international legal system is moving towards a global governance. If you missed that video, you can return back and you can view one more time the first lesson where we discussed the matter of the global governance. So an international regime itself is part of the liberal approach and includes a set of principles, norms, rules, and decision-making procedures that states and other international actors accept as an authoritative in an issue area. And in our case, this is going to be human rights. Okay. The global human rights regime is based mostly on some accepted principles and norms, but so far it has quite a weak mechanism of international implementation, and this is why most of it is actually implemented on national level. As I mentioned before, the Charter of United Nations, signed in San Francisco in June 26, 1945, actually identified the idea of promoting human rights as one of the main objectives of United Nations. So this is why when you're going to write your essays for a final exam, you can actually link the human rights regime to the United Nations as, or let's say, link the human rights regime as part of the United Nations scopes and objectives. So in order to implement this objective, United Nations created a Commission on Human Rights. This commission was replaced in 2006 by Human Rights Council, and it actually gave it more, let's say, a broader set of tools that would increase the efficiency of implementation of human rights. Now, so the Universal Declaration of Human Rights included a list of internationally recognized human rights, and we can split them in the civil and political rights and economic, social, and cultural rights. I'm sure that you have heard about them before, and we're going to just discuss them now. So, when we are talking about civil and political rights, these provide legal protections against abuse by the state, and they seek to ensure political participation of all the citizens that are part of that nation state. For example, equality before law, freedom of religion, speech, assembly, and political participation, right to vote, and so on and so forth. Economic, social, and cultural rights are somehow new to the global rights regime, and they include the they guarantee basically individuals access to the essential goods and services. They seek to ensure equal social and cultural participation, and for example, rights to have a food, rights to have housing, healthcare, education, social insurance, rights to have equal conditions in work, equal wage, equal payment, and so on. So now we are going to progress to the differences between the civil, political, and economic, social, and cultural rights. So we are going to take it one by one. So civil and political rights have the objective to ensure the freedom, whereby economic, social, and cultural rights have the scope to ensure equality. However, if we challenge this particular statements, we can say that the freedom requires both types of rights and equality must be ensured in both. Whereby we mentioned a little bit, we mentioned that both civil and political rights and economic, social, and cultural rights are interdependent. The civil and political rights are considered negative. These are attributed rights, which means that the state is giving those rights, right? Whereby the economic, social, and cultural rights are positive rights. These are created by the states, right? And they depend on the resources, on welfare level of a particular state, whereby the negative rights or the civil and political rights are cost-free, right? These are individual freedoms. We are born with them. On the other hand, we can challenge these statements and say that for the negative and positive rights, the obligation to respect, fulfill, and protect apply to all types of rights, right? So basically, a state cannot just attribute civil and political rights without creating economic, social, and cultural rights, right? And even though the welfare of a state might not be at the highest level, they still have the obligation to provide them. The civil and political rights are justiciable, which means that they are set up under a strict norms and are part of the judicial systems, right? Whereby the economic, social, and cultural rights are political and programmatic, which means that each government is actually creating their own policies in order to put them in place. However, again, we can challenge them because we said that both civil political rights and economic social rights are interdependent. So all the rights, doesn't matter if they're civil, political, or economic or social, they become part of the judicial system, right? And The civil and political rights are said to be implemented immediately, whereby the economic, social, and cultural rights are usually having a progressive implementation. However, we might say that both of these types actually are have both elements of immediate and progressive implementation. So, for example, if we speak about the civil and political rights, we can say that, for example, while acquiring the independence in the post-colonial states, actually have adopted immediately certain, like the right to vote, for example, right? Or let's say certain countries, while signing a program for economic changes, are applying immediately certain, for example, economic or cultural rights and so on. Now, what is the relation between the international law and the human rights regime? So from the perspective of the international law, the two sets we spoke about above, the political and the civil and political rights and economic, social, and cultural rights are like they work together and are indivisible, right? The Declaration of Human Rights specifies minimum conditions for life of dignity in contemporary world, and each set strengthens the other, so they are interdependent or they're interconnected with each other. And these rights are also universal and apply to all people, which means that once the state has signed a certain treaty that involves human rights, it has the obligation actually to ensure that that it follows the treaty. Now, we cannot speak about human rights if we don't mention the major treaties. So, International Covenant of Economic, Social, and Cultural Rights was adopted in 1966. It was actually enforced in 1976, and all the say all the decisions and reviews that are coming under the economic, social, and cultural rights are supervised by the Committee of Social, Economic, and Cultural Rights, or ECOSOC. Okay. International Covenant of Civil and Political Rights was adopted in 1966, was signed in 1976. There are 168 countries that have signed it, and any decision or any reviews under this particular treaty are supervised by the Human Rights Committee. Okay. Other major treaties that are in enforcing the human rights are the International Convention on the Elimination of All Forms of Racial Discrimination, which was enforced since 1969, Convention on Elimination of All Forms of Discrimination Against Women, enforced in 1981, Convention Against Torture, Other Cruel, Inhuman, and Degrading Treatment for Punishment was enforced in 1987. Convention on the Rights on Child was enforced in 1990. And the last but not the least is the Convention of Persons with Disability, enforced in 2008. Okay. Majority of the states have signed the Convention of Rights on the Rights of the Child. 196 countries are part of it. For the other treaties, the number of parties, signatory parties, vary between 161 and 189 parties. So for you have to remember at least two of them so that you can include them in your essays, and you need to know more or less what exactly they stand for. Now, of course, human rights, same as other branches of international law, are characterized by multilateralism. And if you still don't remember what multilateralism is, I advise you to return back to our previous video and actually see what does it mean. So the main mechanism of implementation of the human rights is a periodic reporting by the state. Okay, and this periodic reporting is performed by a supervisory committee. So it happens in the following, like it works in the following way: the states are preparing reports, and these reports are reviewed by the supervisory committees in sessions where members of committees address questions and exchange views on this particular report. Once the exchange of views ended, the review is complete and the final report is given on the level of implementation of human rights. However, the minus of it is that the committee has no authority to actually decide the extent of compliance or the adequacy of the country report. Now, some treaties include mechanism of individual complaints, which means that a person or an individual can fill in a complaint to the specific committee and make sure, and this is going to be reviewed by the Commission itself. So, for example, the International Covenant on Economic, Social and Cultural Rights allows individual complaints, whereby the International Convention on the Elimination of All Forms of Racial Discrimination does not involve individual complaints. So only half of the parties to the convention permit actually the treaty body to examine them. So basically, even though the state has signed a certain treaty, they actually are free. The state is actually free to treat those views as they see it fit. So even though, for example, a certain commission has decided that the human right, that the rights that are falling under a certain committee, a certain convention, are not actually followed, the state is having the last resort to decide how they're going to address them. Human Rights Council established a system of universal periodic review where all the states which signed that particular treaty have the obligation to present the report. But this is not really efficient as a mechanism, because again, the states are free to treat the views as they see fit, and they actually have the right to not participate in these reviews. Now, if we stay to evaluate the multilateral mechanisms, we could say that global human rights regimes is based on national implementation of human rights, and not all the regions in the world actually can provide this enforcement or judicial enforcement. And so far, it's only the European regional regime that actually supports an judicial enforcement to human rights, whereby, for example, Asia lacks any regional human rights organization, and it has only a modest sub-regional human rights mechanism. On the other hand, for example, we discussed before about the International Criminal Court. International Criminal Court can be considered a multilateral mechanism of implementation of human rights, but in the same time it only restricts to genocide, war crimes, and crimes against humanity. Most of the multilateral mechanisms actually develop some persuasive conversation in human rights, which means that they are encouraging the compliance, and this actually allows this allows the committees, the supervisory committees, while they're reviewing certain cases, to study the national law and practice and actually see what exactly is the core of a certain violation of human rights. States, the multilateral mechanism actually of enforcement of human rights allow the human rights regimes to allow the international regimes to actually develop the mechanisms against the states that have gross and systematic violations of human rights, and push them to actually move with slower steps, but still enforce human rights in their national regime. So, like, for example, if we would speak about the Middle East, we can mention Saudi Arabia here, and we could particularly mention the women's rights in this case, right? So for a very long time in Saudi Arabia, the women were not allowed to drive, for example, or any cinemas were not allowed, and so on. But lately, after the Arab Spring events, actually, they moved towards broader rights for women. The international norms in terms of human rights have also an independent impact, whereby the governments actually cannot legitimately deny their actions since they have signed a certain treaty, which means that, for example, if a certain commission has enough evidences that a certain country has violated the rights in a certain field, they can address them, and the country is not really able to deny that they have committed certain violations of it. The enforcement of human rights on local level is also facilitated by the constant growth of the civil society, and the local civil society actually has enough triggers, or has enough tools to address the human rights violations to their governments, and to move towards certain changes. The human rights norms also facilitate bilateral and transnational actions, and whereby, for example, certain governments that already addressed certain rights, they can push other governments who are violating human rights to address them as well. Now, as part of your homework, you have to reflect on the following two questions. Both the information for these two questions can be found in Globalization of World Politics, chapter 31, Human Rights. So you have to read the paragraph, The Bilateral Politics of Human Rights, on page 502 and 504. And you have to assess the effectiveness of bilateral actions towards the enforcement of human rights. And you also have to read, after you read this paragraph, you'll be able to answer the questions to the case study 31.41 on page 503, International Responses to Tiananmen Massacre, page 503, and you have to answer the 2 questions you see in front of you. This is all for today. If you have any questions, you can address them, and see you.